Hi, welcome everyone to this. Sorry, I have terrible echo. Yes, I can hear you, but I have like lots of echo. Uh, this will not work. Um, one more try. One more try. No. Yes, will do.
Welcome, everyone. I'm sorry we are having some technical difficulties, so I'm stepping in as our moderator is solving the issues. So we are hosting this session today to discuss the new or to discuss the proposal for a data act and the fact that that proposal is lacking a revision of the database directive, as many people were hoping that it would have. We have today with us as speakers from the European Commission, and I'm sorry I was not supposed to be in this role, and now I'm missing the names. So we have. Uh, I'm sorry, I'm not really having the names with me in front of me right now, but we have Felix Reda with us. We have Professor Martin Uzevec. We have Christoph from the European Commission, and I'm missing your last name. I'm sorry. I was supposed to also talk on behalf of COMMUNIA, and we're supposed to have Paul Keller as moderating the session. So I'm not really sure how this is going to go from now. But the idea for this session indeed is to discuss the options that we have seen in the proposal in terms of making a target revision of the database right instead of a wholesome revision of the Database Act. So let's see if Paul can already join us as moderator and if I can leave this function. But
Okay, I will. I hope you can hear me now. I don't have that terrible echo anymore, so I'm assuming this is working much better than before. Thank you, Teresa, for doing the introduction, and my apologies for putting you into this place. You've briefly introduced the four speakers and also the topic. I may want to say a couple of things about why we're hosting this as COMMUNIA. So, as COMMUNIA, we've always been very critical of the sui generis database right that was introduced in the 1996 database directive. From our perspective, that is really a prime example of an intellectual property right that has been introduced with a certain purpose, where it is relatively clear that it has failed to achieve this purpose, and that is with us more than 25 years later in a sort of zombie fashion. And as Teresa mentioned before, there were indications that the Data Act proposal would include a review of the sui generis database, right? Whatever a review means. But I think a lot of us hoped that this would really be something of a revision that would take another critical look at how the right functions and if it's still the right tool for the right job. What we have now seen in the proposed Data Act that was presented last week is let's call it a small carve out from the right for certain types of data or for databases containing certain types of data. And so we are, of course, still interested to see what this means for this right, what this means for the future of this right. And that's why we will, from COMMUNIA's perspective, follow the proposal for the Data Act, at least in this specific point. And with that, maybe it's a good moment to hand over to our first panelist speaker, Krzysztof Niczynski from the European Commission. He works in the copyright unit, and it's maybe important to note, but maybe he does it himself as well, that the copyright unit is not responsible for the proposal of the Data Act, but as we have understood in conversations with them, the copyright unit is responsible for Article 35, which is in Chapter 10, which is this carve out from the database, right? But Christoph will undoubtedly be in a position to tell us much more about this and about the thinking behind this particular article and maybe leaving out some other options. The floor is yours, Christoph.
Hi, hello, good afternoon, everyone, and thank you very much for having me at this event. It's really a pleasure to be here. So my name is Krzysztof Niczynski, and Teresa, you are totally excused. My family name is very difficult to pronounce and to remember, so no worries at all. I, I would like to argue, although what Teresa and Paul said, then there is a bit disappointing. You were hoping for a much broader review. But nevertheless, what we did is quite important change and can make a difference actually. So let me maybe start indeed with saying then I'm working for the copyright unit, and indeed our unit was not in charge or in the driving seat for the Data Act as such, but we were cooperating closely on this intervention on the database directive because indeed it is within the Data Act itself. It's not a separate document. It's not a separate amendment to the database directive itself, but it's a provision within the Data Act regulation. And maybe without going into many details on the Data Act itself, I would like to mention two measures that are actually really important in the context of the intervention on the database directive. So first measure is the measure that allows users of the connected devices or IoT devices to have access right to the data that those devices generate. This is a clear right that that Data Act includes in its provisions. Secondly, users can actually request to share this data with third parties. So this is one measure called also B2C or B2B, so business to consumer, business to business provisions. The other one which is also important in the context of the database directive, is the right of the public bodies to request certain information from private companies in case of so-called emergency situations. And this is called B2G part of the proposal, so business to government. So what have we done with the database directive, which again I think is pretty significant and important. So we identified the most relevant problem that users and database makers at the same time faced, namely the interaction between the sui generis protection and IoT data or databases containing this automated data gathered or obtained through the sensors of the connected devices. That was a clear problem with understanding whether in such situations sui generis can be invoked to protect such databases. And of course, with the evolution and speed pace of the development of the data economy, and especially this kind of data, even though at the moment the database directive and this part and application to this kind of data doesn't create many issues, we believe that it can in the future. It has potential that this kind of databases would become more and more commonplace, and data holders could incidentally, opportunistically use sui generis protection to limit access and use of this kind of data. Again, data that are becoming crucial for the development of the data economy. So what have we done? We made it very clear, and there is recital 84 and article 35, saying then databases containing basically IoT data, or according to the nomenclature or notions used by the Data Act, data that are generated by the use of product or related services. That is what exactly Data Act uses, but it's in essence those are IoT devices. In such situations, sui generis do not apply. To avoid any possible misunderstandings and risks that nevertheless data holders of such data would like to invoke sui generis to hinder this access right that I mentioned that Data Act created for data users and third parties, Article 34 exactly explicitly says that such databases are not covered by the sui generis right, and this right should not be enforced and exercised in order to prevent effective functioning of this access rights created by the Data Act. So I think, as I said, then this is important provision without which we could face the situation then this data access right created by the Data Act could have been seriously hampered by this provision. But again, it is not only for the purpose of the access right created by Data Act, but we're saying in general, then such databases, again, containing basically IoT data, or again, using the language from the Data Act, data generated or obtained through the use of the product and related services, and the definition of product and related services you can find in Article 2. But basically, again, this is IoT devices that never is covered by the sui generis right. So it's a little bit broader, actually, clarification that hopefully from now on will settle this, let's say, discussion whether it's covered or not. So this is one intervention, as I said, maybe targeted and one could say limited, because we don't have the full-fledged review or amendment to the database directive, but it tackles actually the most relevant issue that we identified also through the study, also through discussions with stakeholders. And second intervention, a bit smaller, one could say, is exactly in this B2G part of the proposal, where again, just as a reminder, public bodies in these exceptional situations can request private companies access to data, and they can use them exactly to tackle those emergencies. And in such situations, we also say, but this is only in the recital 63, then the database maker or the data holder should exercise the sui generis right. So we are not saying this time around, and the sui generis right does not apply like in previous situation that I described. But here we're saying that the database holder or the data holder should exercise this right in a way that does not hinder the effective application of this B2G provisions. So does not prevent public bodies from receiving this important information in these exceptional situations. So that's it in a nutshell. Two interventions that Data Act includes on the database directive. And as I said, despite maybe at a first glance it looks limited and targeted, I fully agree. But at the same time, I argue that we tackle the most relevant and most important issue identified, especially when it comes to the data economy, and with huge potential of being disruptive, especially to data sharing and data use. And to some extent, we wanted to prevent this kind of negative influence of this right to the sharing and use of data, and hopefully we will manage to indeed prevent this kind of situation. So thank you very much for your attention, and looking forward to the discussion and question on this, if any. Thank you.
Okay, thank you, Christoph, for this very clear explanation. And I think we'll save the reactions and the questions for the end. So let's go straight to Martin. Yeah, Martin, the floor is yours.
So much. So first of all, I find it a little bit difficult to disconnect the provision with the Data Act as such. So I will have to comment also on some of the design features of the Data Act, and I'll explain why that actually is. So in terms of the Data Act as such, in general, I think I like the design and the direction that it goes. I think it replicates some of the existing legislation, which also begs question to what extent it will work. But I think the design is generally intuitive. Now, specifically the sui generis database protection. I also understand the proposal made by the Commission, but I think the way that it's currently drafted needs a little bit further thinking, I think. So first of all, I take issue with calling it clarification, and this might sort of bring back memories of some previous discussions on some previous proposals, but I don't think this is a clarification. It's a subject matter change, and I think Christoph also referred to it as a significant change, and I don't think it follows from the case law fully, because I could imagine some of the databases that even under the change in the case law could be still protected, and under this proposal will be excluded from protection. So it is subject matter change, and for these databases, we will have a carve out in the Data Act for protection. So I don't think it's a clarification, it's a real change. Second, and I agree, that significant change, which will revolve a lot about around the definition. Second, I think something that doesn't come through from the text, and that really needs to be tightened because it might create problems in the future, is the fact that this proposal is not only carve out for a certain type of data, but also is a retrospective carve out, meaning even the old databases that were protected before the entry of this regulation should actually be carved out. Now, there's no explicit provision of that kind, which means that there could be obvious questions about what about the old databases. And I think the assumption here is of the European Commission is that since there's no silence and we say it shouldn't apply, it should apply even to all databases. But people could argue that if this was intended, there needs to be an explicit provision of that kind, which there isn't. And I recognize that I think the Commission is trying to be retrospective here. Now, some people could say, well, how can you carve out something can you exclude something from protection that was previously protected? Is that acceptable, since these databases would be protected under Article 17 of the EU Charter? And the answer is, I think it is possible. And I think it is possible particularly because here the Commission not only excludes something, but also transforms the regime for these databases. So yes, it strips them from protection, but actually for the old databases that would be still protected, say for 14, 13, 10, whatever years, it offers something else. And that something else is a data access regime coupled potentially with compensation and few other obligations that I'll touch upon in a second. So I think constitutionally it's totally acceptable, given the other features of the Data Act, to strip the old data sets of protection, but it needs to be explicit, and I think this is currently missing from the proposal. Now, the additional problem that I have is that I generally sympathize with the current scope, sort of a product use data. Although I think there needs to be a little bit more recognition of the fact that this will also exclude other types of data that are produced with help of a physical token. So, for instance, a club card data, where you have a grocery store and use a club card to collect the information about a consumer consumption. That kind of data would also fall under the definition of the product, and it's not a kind of IoT scenario that probably Commission is thinking about. I'm not saying that's a bad outcome, but I'm saying there are some collateral databases that will be also excluded. And I understand that this definition is preferred to machine generated because that creates a lot of confusion, but still it has to be recognized that this is the case. Now, what this proposal doesn't solve, I think, is the problem of database directive scope. So because because it tries to exclude protection of certain databases in a very roundabout way, it does not change in any way the case law that says that database protection only applies to this very small subset of databases, which actually creates a risk for the future, that national legislatures in the member states will decide to offer some type of protection to IoT linked data that would be outside of the scope of a database protection and thus not preempted by the database protection. And I think this is a risk because obviously Commission wants to avoid fragmentation. Hence, I would advise that actually question of preemption and scope of the database directive is approached much more head on than it's currently the case, because it also risks, in addition to that, is the fact that private ordering through contracts can partly undermine some of these provisions, obviously outside of the mandatory provisions of the Data Act about data access. So I think from that perspective, it's a little bit short-sighted to only focus on this specific subset of data, because whatever happens outside of your definition is kind of not considered by you, and that means that you're putting all the fate in that definition, and obviously definitions can fail you from the long run. All right, so last two quick points I'd like to make. I said that I think it's possible to exclude some of these databases from protection because you give something in return even to the old owners, and that something is friend conditions in Article 8, where you say that that third party reusing data should negotiate with the data holder fair, reasonable, non-discriminatory conditions. Now, it's not entirely clear to me, and I understand this is not this unit's responsibility, whether that refers to conditions in terms of compensation for the administrative cost or actually a license. And if it's the license, I know that there is some cap on the cost, but if there is a license, then the question really is that we are with one hand we are stripping databases of database protection. On the other hand, we are saying irrespective of that status, there is an obligation to pay for third parties. And I think that might be intuitive, but I'm not sure that that we have thought through all the consequences there. And there's then one requirement that I don't understand at all, which is the requirement of non-compete, where basically the third party that ports the data from the data user is not able to use the data to compete with the original data collector. And that just escapes me why that should be the case, because it actually makes the situation worse to say a farmer who today gets the information from the provider of equipment and then can just port it somewhere else without that someone else having to pay for the data or to be obliged not to compete with the data. So that I don't understand. Finally, the very last point, trade secrets. I understand that the entire proposal navigates trade secrecy in a kind of a very careful way. But one thing I find a little bit striking is that it's the proposal itself that actually defines what is eligible as a trade secret, because transparency obviously kills secrecy. So saying that you have to respect trade secrets to the extent that they exist is a little bit circular, because you are defining what is public and what is not public. Hence, how can you be saying that trade secrets are kind of protected entirely in parallel, because you are actually encroaching upon something that could be otherwise claimed as a trade secret. So that's the part that I'm also not fully understanding, and obviously will have impact from on this, although it's not directly on the sui generis database. So that's all what I have for now.
Okay, thank you, Martin. And there were a couple of questions that maybe Christoph can provide answers to. But as I said, I would suggest we first go through with the initial presentations. And given that, I would now want to hand over to Felix. Felix is here. We asked him to talk a little bit about more practical consequences that arise from the existence of the sui generis database right. And I think Felix is going to talk about a pending case in Germany at the moment. The floor is yours.
Yes, thank you, Paul. Indeed, when we were preparing for this event, we were joking about, well, how many people really care about the sui generis database, right? Luckily, as we can see from the engaged audience, quite a few people care if you just put it like that. But nevertheless, I think it's important to always bring the issue back to the real people who are affected by this legislation on the ground, and why perhaps not reviewing the sui generis database directive entirely is a missed opportunity to make life easier for ordinary European citizens. So I want to talk on behalf of GFF, the Society for Civil Rights, about an ongoing court case that we have in Germany, where a journalist and an open data activist are actually being attacked by a government agency under the guise of the sui generis database, right? So we're dealing here with a lawsuit under civil law, but also criminal proceedings that have been started on request of this government agency against the journalist and an open data activist. So the data that we're talking about in this case are house coordinates. So this is geodata that is extremely useful for all kinds of mapping applications, but also for journalistic purposes. So it's data like postal codes, addresses of houses in Germany, but also the outlines of the houses in space. So you actually know how large a house is, and information such as whether or not that a house is an administrative building or somebody's home, and so on. So all of this data is factual. Usually copyright would have nothing to do with it, because as we know, there is no copyright in fact. However, there is the sui generis database protection for this database of this house coordinate data. The house coordinates are actually acquired by each of the 16 German states. And quite ironically, some of them have already made this data for their state available as open data for anybody to use. But unfortunately, not all 16 states have done so. So this administration that has started the lawsuit, the so-called ZSHH, which is a Bavarian agency, has the there was a question about the case file. I will post a link in the chat as soon as I'm done. So this Bavarian agency that has started the lawsuit has the task of actually taking the house coordinate data from each of the 16 states and combining it into one database. And it is then selling access to this database to companies and other administrations for quite a steep license fee. And actually, the European Union has already been pretty clear that this is not exactly the business model that is in the public interest, because what it actually means is that large companies such as Google that offer applications like Google Maps are able to buy this data for a license fee that doesn't really hurt them. But small companies or even public initiatives such as OpenStreetMap are unable to use the data because it's not available under a free license. So this really has nothing to do with what the intention behind the sui generis database right was initially, which was to encourage the creation of new databases. This is data that actually is being collected by the state anyway. This data would exist whether or not there was a business behind selling it for license fees or not. This is part of what the public sector has to do. So really restricting access to this data is detrimental to society as a whole, because journalists and open data activists are being kept from actually using this data to make new applications, to make new visualizations, and so on. So the people in question basically found this data on a government website. So you could argue, well, actually, this kind of lawsuit should not be possible anymore, because in the Open Data Directive, which I also worked on when I was in the European Parliament, a carve-out was created from the sui generis database right. So pretty similar to what we have here now with the Data Act. And I just want to bring up this example that this lawsuit is happening anyway to show why maybe this approach of carve-outs is not a good approach. Because it may well be that it turns out at the end of this lawsuit that the administration was in the wrong, that actually they were not allowed to rely on the sui generis database right. But there are a lot of hurdles to prove that. First of all, you have to prove that the Open Data Directive is actually applicable to this particular data set. And there could be reasons why it is not. Also, perhaps the way that Germany has implemented the Open Data Directive may not be correct in this respect. But just looking at the law, it's very difficult for somebody who is perhaps not an expert in the database directive to know that. If you just look at the German copyright code, it says that this database protection exists. And this was also enough for the German agency to send a takedown notice to GitHub, which removed all the data from the publicly accessible repositories. So even though the open data activist and the journalist may very well be in the right, and they may actually have used this data legally, the fact of the matter is they're not able to use it right now. They had to get legal advice. And whether or not this data will eventually be reinstated is very much an open question. If the sui generis database right simply did not exist in the German copyright code, none of this would be happening. So perhaps this is one example how, from a practical perspective, this is not the most straightforward solution, and perhaps should give us pause for thought whether we don't actually need a general review of the database directive to avoid this kind of situation. I will leave it at that. Very much look forward to the discussion. And I will post an article about the case in the chat for those who wish to follow up.
Okay, thank you, Felix. And I think we'll continue straight away with Teresa from COMMUNIA to share some thoughts from our position on what we've heard so far and also on the proposal. And then we hopefully have about 20 minutes left for discussion and answering questions. And there are already some questions in the chat. Feel free to put questions that you want me to ask to any of the panelists into the chat while Teresa speaks. Teresa, the floor is yours.
Thank you, Paul, and welcome again. So I think the point that we want to make from the side of COMMUNIA is that the introduction of this right has shown us how difficult it is to politically retract from new rights, even when there is no evidence that they contribute to the assumptions and objectives that had originally justified the introduction. But what we see now, and we have seen from the previous what was said by the previous speakers, is that the scope, what remains from the scope of the sui generis rights after all these legislative carve-outs, if you consider that they are indeed carve-outs, and after the conditions and imposed by the Court of Justice for exercising and enforcing the rights. So what we see after this is that probably not much remains, and is it really worth imposing additional restrictions to the use of data and information when there's not much of that scope remaining and when there's no demonstration of societal and economical benefit on having this right? So those are our questions, and we think that we are, we have always thought this, and we have been saying this for a long time, that policymaking in the area of copyright is always battling with social legitimacy. And we think that at this point, it would be healthy to simply acknowledge that this experiment was not successful, and a revision of the directive as a whole would be the right step forward. So, and I think it's worth mentioning, so when we say there are no societal or even economic benefits in protecting data as property and in attributing these sui generis database rights, which are exclusive rights over data at the end of the day. So when we say this, we are thinking that protecting for us, and as you know, COMMUNIA, this is a very basic principle for us. Public domain is the rule and copyright is the exception. So when you want to constrain the public domain by creating new rights, you should do it based on the principle of proportionality and based on this clear economic evidence, which has been demonstrated by the revisions, evaluation reports like the 2005 and the 2018 evaluation reports of the directive. The empirical evidence is not there. The empirical evidence that the right has helped to create additional incentives to the production of databases in the EU is not there. Actually, what we can see from the reports is that the existence of these rights has had no influence in the majority of database owners' decision to invest in collecting data and creating databases and verifying the content of these databases. So, in one hand, the level of protection granted by this right is not economically justified. On the other hand, we know that the right indeed creates an obstruction for access and reuse of basic data and information. And this negatively impacts societal activities that depend on the availability and reuse of data and information, such as academic and research activities, the activities of libraries and archives. And it has a chilling effect on users, this two-tier approach to the protection, where users simply do not attempt to utilize databases out of confusion or because they fear that they may be infringing on a right that is actually very difficult to understand, even for people with legal backgrounds. And And another point is that this right leads to the enclosure of the commons of information. So we have public domain data that could otherwise be assessed and reused and is locked down by this right. Not to mention that this right also allows databases to be potentially protected forever. So we think that the costs and the analysis of cost benefits shows that the direction should be to simply withdraw the sui generis database for future cases. And for existing databases that should continue to be, of course, protected under the existing rights until the term of protection, we should improve access to such databases. So one of our first asks, if we think about a revision of the database directive, is that Article 10.3 should be repealed. So the possibility of continuously renewing a right is a fundamental threat to the commons of information. So substantial changes to databases that have been grandfathered in should not benefit from an additional term of protection, as that would enable the possibility that such databases could be protected forever, preventing them from ever entering the public domain. So that's one very practical measure that we would ask. Another would be, of course, to delete the lawful user condition from Article 8.1. We know that the right protects substantial parts of a database. So why are we conditioning the use and reuse and extraction of insubstantial parts of databases, which are outside of the scope of protection of the right to lawful users? So that's another one. And then we have all the possibilities of improving the exceptions regime of the sui generis database right. We have the private use exception in Article 7a that should not be limited to non-electronic databases. We have the teaching and scientific research exceptions that could cover and should cover the acts of reutilization and not just extraction. The possibility of member states applying all of the exceptions of the InfoSoc directive, the protection from contractual overrides. So there's plenty to do there. And on the other hand, here, just to mention one extra one that we see that could be used, which is an extra improvement that we see that's worth doing at this stage, which would be to allow public sector databases to be made available for free to use and reuse without restrictions. So existing databases that were produced in the exercise of the public tasks or with resource to public funds should be available to the public without restriction. So that's it from our side. We see plenty of opportunities and needs to improve the database directive, and we would hope that's the way forward after this proposal. Thank you.
Okay, thank you, Teresa, for this. So we're essentially open for questions here, but I sense that maybe there's some things that Christoph might want to reply to. There were maybe a few questions also of comprehension in Martin's presentation, and maybe you want to also react to anything that any of the other speakers have said. So if you want to start, and otherwise I have a couple of follow-up questions from the chat and also questions that I have prepared. But maybe let's see where your intervention takes us, Christoph.
Yeah, thank you very much. Very interesting points raised. Maybe to what Martin said, that for him it's not clarification but subject matter change, and it what I said about that it's significant clarification kind of proves this. So maybe let me clarify here that why we think it's significant or have a significant potential, those changes or clarifications. It's mainly when it comes to the impact and future impact, because right now the protection of databases with IoT data do not fulfill the criterion for protection. And it's really something that is underused, the directive itself and sui generis protection. It's from what we see, it's used in the traditional database businesses like publishers, and that's where the instrument is indeed used quite often. But in the IoT context, not really, and also it doesn't qualify for protection, for instance, because the conditions are not met. Nevertheless, now the situation changes quite dramatically with the Data Act, because it opens this right for access to data, and that can provoke some data holders to kind of opportunistically use this right to prevent this, and that's something that we want to prevent from happening. So that's why I was saying that this clarification is significant and has a potential to make a difference in the future and avoid this kind of situations. And you also, Martin, said about fragmentation, because member states themselves can introduce some measures to protect, for instance, such databases. But here, where the advantage of the regulation comes into place, by the way, so it's directly binding, and we don't have this transposition period. We don't need this transposition measures that can differ, that can create some indeed divergent transposition measures on national stages. Here, it's clear cut set, comes into force immediately after adoption, and should exactly make sure that it's applied equally in each member state. So the understanding that this type of databases are not covered should be clear to everyone, and this instrument helps in that. So about Felix, what Felix said, I would of course be happy to look closer into this case. Just what I wanted to say is that Open Data Directive has a bit different provision. It's not carve out like we have, like we proposed now, because in Open Data Directive, the directive doesn't say that this right, sui generis right, does not apply. It says then it should not be used against this kind of requests from the public to the institutions. Here we are saying very clearly, explicitly, that the right does not apply, and that is huge difference. Except this provision that I mentioned as a second intervention in the Data Act, where we are talking about this business to government data sharing. This is indeed different, but the major part of the intervention when it comes to the B2B and B2C, we're saying very clearly then sui generis does not apply to these databases containing IoT data. So I think this is significant difference that should stop this kind of litigations, because there's no discussion here. When you say like in Open Data Directive, then well the right applies, but it should not be invoked against, then indeed it might create certain issues. I agree, but again, happy to look closer into this particular case. And what Teresa said about even like repealing the directive or the sui generis right, this is indeed tricky for many reasons, because it's acquired right. It's right that is used actually, but more in this traditional database intensive industries, let's say, and has potential to be used again because of this uncertainty for IoT. But now we are hopefully solving this problem. That's why like abandoning or repealing this could be very difficult. But I would like to make very last point, because maybe this is something that sometimes escapes us. So the recent Court of Justice judgment in CB Online case, which introduces this infringement test, and basically says then the sui generis is only infringed if the investment of the database maker is in danger. Otherwise, there is no infringement. So this, in a nutshell, of course, but this case also changes the landscape and understanding and interpretation of the directive quite significantly. So I think we should look and follow up on this judgment, how it is implemented in practice, how courts are implement this, and this might be a correction in going into the direction of what you are saying, of what you were expecting, that would limit this. Sometimes, indeed, I agree, negative impact of the directive. Thank you.
Okay, so I want to like maybe this is a good moment to also follow up with one of the questions from the chat. In the chat, people have asked if the fact that the review of the sui generis database right in the Data Act is now this very targeted review. I think that's how the Commission also refers to it. It has taken the shape of a very targeted review. If that means that there will be no wider review of the database directive or the sui generis database right in any other instrument. So it makes I tend to agree with what you said, that it is coherent in the scope of the directive that this carve out takes place, because it enables all these other policy objectives. But I think the questions that people sit with, including I think ourselves to some degree, does that mean that the Commission has really decided there's nothing else that requires fixing with the sui generis database, right? I'm also asking because the study that was published alongside at least identifies a couple of, I think it's called supplementary policy options that go a little bit in the direction of some of the things that Teresa has mentioned. So a expansion of the copyright exceptions to the sui generis database right, or the exclusion of public sector bodies all out. But these obviously have not been taken up in the Data Act. And so the question is this from the perspective of the Commission case closed for now, or is there maybe something that will be coming up after the Data Act has been dealt with?
Yes, so indeed, our intervention was purposefully narrow to be in line and consistent with the Data Act. And Data Act focuses on this IoT data and access and sharing of this kind of data. So we had to align our intervention, and also at the same time, as I mentioned, that was the most relevant problem that we identified. Also, the study identified this as a most relevant problem. And if you read the study, you see that they proposed several issues how to deal with that. And then you have indeed these supplementary options. So at the moment we are where we are. We are with this proposal. So we are working on this, and this is on the agenda right now. I'm not in the position to be totally honest with you to say more on this. Of course, we are not excluding some other changes if that would be on the agenda for one reason or the other. But at the moment, it is indeed not, because we are focusing. We wanting to make sure that these provisions that we propose in the Data Act are agreed, come into force, and this is something that we identified as most burning and pending issue that needs to be solved. Also, we of course went through the other suggested or other options mentioned in the study. We didn't find compelling arguments that it needs to be done urgently, and especially within the Data Act. So again, taking all these things into account, we decided then the best option would be to address this pending issue that we believe is quite crucial and might be critical in the near future. The rest, it's not like written in stone, and now the directive will stay like it is. There might be future discussions about this, but honestly, I cannot tell anything more about that than this, basically. So every possibility is on the table, but for sure, first and foremost, we need to now focus on making sure that this proposal is adopted and comes into force as soon as possible.
Thank you. And I think, Martin, you had something to add to this or the issue we discussed before.
Yes, I wanted to react to Christoph. So I want to react to these 2 points because I think they're really crucial. So the point about clarification, I mean, this is not just sort of a picking words. I think this has a really far-reaching consequences for what the member states will be able to do after this is adopted. So yes, you say this is a regulation, it will directly apply, but what does the regulation actually say to the member state? It says the directive does not apply. It doesn't say no protection shall apply. It says the directive doesn't apply. What does it mean? It means that if the directive doesn't apply, it's outside of the scope. If it's outside of the scope, it means that it's actually not preempted by the directive either. So had you said the directive does apply, it's in the scope, but it's not relevant or substantial investment, in this case, it shall be presumed, then the argument would be it's preempted by the directive. Hence, the member states cannot introduce any protection in that area because it's preempted by the directive. But here you're actually helping the member state. You're telling them, oh, it's outside of the scope. So if it's outside of the scope, and with the reading that the Court of Justice gives us in Ryanair case, this actually gives you a suggestion that the directive does not preempt this at all. And you're kind of actually helping this argument on the national level. So I think I think actually it's not very useful to design it this way, because you can actually create the risk of fragmentation as opposed to closing it, which you would solve if you would bring it in and say, no, this is carved out and nothing can be introduced on in this space. So this is the first point about a clarification. And the second that sort of follows from this is that, clarification also, if we have this dispute, is this clarification or not? There's obvious way to resolve it. If I bring you one single example that in my reading would be protected under existing case law and would fall under your definition, then the result should be that it's not a clarification. And I think I have such examples which fall under your definition. Now, again, it's not just because I don't necessarily mind the outcome, but for those owners of those databases, the outcome is that they will now, because of the regulation, not have the protection. So they could bring in a claim against Article 35 of the Data Act saying, this provision is stripping me of protection implicitly, even despite the fact that I had this protection promise for 13, 12, whatever number of years. In which case, you want to have a strong ground, right? You don't want to flood the space for the coming 14 years with litigation about, is this applicable only to new databases or to old databases? So this is what I'm talking about. If you want to have a strong case that this is stripping them, and I think it strips them in a constitutionally compliant way because it gives them something in return, that is the data access regime coupled with the compensation and all of that. So I think that is possible. But in this not being explicit and actually hiding a bit behind clarification, I think makes a false impression that what it actually is, which means that if the court interprets this and asks if there's inbuilt sort of temporal a limit to this that would also apply retrospectively, I don't know what the outcome could be. I wish that the outcome is in line with your intentions, but I could not really predict it. And if a client came to me, I would say, well, you can litigate this. It's kind of open as the wording stands. So it's not, I'm not trying to pick the words. I'm trying to talk about two real outcomes: fragmentation coming from the member states, and second, litigation coming on. What is the temporal scope of this provision?
Okay,
Well,
so we're running up to the hour. I just want to acknowledge that some people may have had this as an hour-long event in their agenda. If you have to leave us now, thank you for being with us today, and you can watch the rest of what we're going to talk about. Like, we'll try to wrap this up within 5 or 10 minutes in the video recording, which we will post in a couple of days. So thank you for being with us. I think, Christoph, you wanted to react to what Martin said, and there's also 2 questions in the chat, which I could either read to you, or you could you could actually react to them directly, because I think you can read the same chat as I can. But maybe first react to Martin.
Yeah, to Martin, just very quickly, very good points that of course food for thoughts. But when it comes to this fragmentation and member states enacting their own protections, that could happen pretty much every time, unless we would say this very explicitly, then it's forbidden. So you know, there are plenty of situations like this. Then we don't say this in the European legislation that it is forbidden, but member states nevertheless don't do it. And here we are like saying that protection for this kind of databases were never intended at the first place. So the whole rationale of the database directive was to protect something else, to protect data production, not accidental data, you know, as a byproduct. So if the member states nevertheless would introduce national legislation that goes against this, that would be maybe not directly, but at least indirectly against the rationale of the directive. So I would be a bit surprised that they would do it, to be honest. But I cannot exclude this at this point. That's true. The only way to exclude this would be to have a very direct provision that would tell member states, no, you cannot do it. But this is very often not how the EU legislation works. Sometimes we just you know, propose legislation, and then member states in kind of a spirit of this legislation you know, act on in domestic situations. When it comes to your second point about the legacy, let's say, databases that would be covered, yeah, we believe then at the first place they should not be. So if someone, you know, claims protection for the database that you know, contains data gathered by sensors, we think he's wrong. We think there is no, the criteria are not fulfilled, and it was again never intended, the protection for such situations. But again, we are at the very early stages of this kind of temptation to protect this databases, because from what we see, this is not the case. This is not the case because database makers understand, and this is not the instrument that protects. Plus, these conditions are not met. So, for instance, substantial investment. But again, very good points, and thank you for this discussion. Happy to continue.
Okay, so I would like to point you to 2 questions. Maybe the one which is a little bit more straightforward first, which comes from Matthias, who writes, "I have a question to Christoph. I'm curious about what you said about market players and their behavior in light of legislation. Is this something you modeled based on consultations, market observation, legislative comparison, or third-party testimony? The impact assessment and the staff working document don't elaborate."
Yeah, so I understand this is a question about how we supported our intervention. So yes, we had consultation with stakeholders actually as a part of the Data Act public consultation, and we received certain feedback. We had also a separate consultation within the supporting study, and we also you know, based our our intervention on the 2017 evaluation of the database directive. So if the question is about this, those are the sources which are available and which you can also have a look at, and especially the study and conclusions that the study came to, basically.
Okay, I hope this answers it for Matthias. I will. The other question is from Estelle, and Estelle wonders about the language in recital 84, which is the one corresponding with Article 35, and specifically about the use of where. I think so. It makes probably more sense if I read you the question, and maybe you can answer based on that. She finds it confusing because recital 84 says data in databases obtained or generated, but databases where data is obtained can be protected by the sui generis database right. So the where is confusing. Does it mean all databases which normally would be subject to the sui generis database right or not? I don't know how deep you are in your own recitals in order to be able to answer that, or if you have me to read this. But maybe you can just also say something about the intent of the recital that should also answer it.
Yeah, I think I know what the question is about. Let me have a quick look at the recital itself. The main the bottom line is this databases are not protected, and the recital says in one place where such databases do not qualify to sui generis right, they are not protected. But actually, it's kind of a language issue. It rather should be read because such databases do not qualify for the sui generis right. So maybe it's formulation or wording that is a bit confusing. I think I understand where the question comes from, but the rationale of this sentence is exactly this: because they are not qualified, they are not covered by the sui generis right. I hope it's answers the question, but indeed it is a bit. I can understand a little bit of a confusion coming from the reading here, but this is the intention to say then in such situations databases do not qualify.
Okay, thank you. Estelle says that then it should be changed. So I think there's amendments coming. There will be amendments coming anyway. We're 10 minutes over the end time, and some of us have subsequent things. So I specifically want to give the opportunity to Teresa and Felix to maybe intervene once more, and otherwise we will slowly wrap this up. Any?
Well, yeah, I would just like to welcome the possibility. So Christoph could not reveal the plans of the Commission, but the fact that this is not closed, I think we welcome this idea that there's still a possible reform of the other provisions of the database directive, and I think it would, of course, be for the reasons that we already explained, and mostly for legal certainty and for facilitating access and reuse of data and information. I think all of us would be very satisfied, and we think it's urgent. Maybe the Commission doesn't, but we have been in this situation for 20 years, so it's about time. Thank you.
Felix, you're muted, I think.
Sorry. I would just like to add that for member states, the sui generis database right is a topic that is not very well understood. And so I would like to echo what Martin has said, that it's probably necessary, if you want to restrict the scope of the right, then it has to be mandatory. So simply saying the directive does not apply in this context, would still require the member states to actively reduce the scope of the existing sui generis right that they have in national law. And I feel they're only going to do that if they're actually required to do so, because it's always easier to leave everything the way it is, which is probably why we are in this situation in the first place. I think the experience is that it's very difficult to get rid of any related rights once it has been introduced. And probably the initiative for that will have to come from the European level.
Okay, thank you. So let me close this with by referring to something that Christoph said in one of his last interventions. You pointed to the rationale for the sui generis database right when it was introduced in the 1990s, right? And that was to encourage the production of databases. And so we have a right, and there is, I guess, discussion if it achieved this objective or not. But one thing that is um, that is pretty clear to me, at least, in also thinking about the whole question again when preparing this, is that we are, of course, living in a radically different environment, right? Nobody needs to incentivize to produce databases anymore. Almost everything we do every day, that corporations do, that industrial processes do, ends up bloating even bigger databases. And I think this new wave of data governance regulation that the Commission has started to roll out in the context of the data strategy is a sign of a complete of these completely different environment, and calls for different types of interventions. And we're seeing this thing that there's these various carve-outs in the Open Data Directive, in the Data Governance Act has a similar carve out. Now the Data Act has a carve out. So maybe I would argue there is probably a need to think about the role of the sui generis database right in the European data economy on a maybe much more fundamental level. That doesn't take away that the rationale for this carve out in the Data Act is there, as you explained, because otherwise these policy objectives would not be achievable that you're trying to address with this act. And so this is probably the starting point of a longer discussion. I want to thank all of you for contributing to this. I want to thank our audience for staying with us for so long. And we'll undoubtedly be back with more discussions as this proposal evolves. And for now, I want to wish all of you a good afternoon, and take care, and have a nice evening. Bye-bye.
Thank you very much. Bye-bye.
Thank you.